And Jamuna Devi had a daughter, Savitri Devi.
That's right.
Savitri Devi was married to Nathuni Swami. And from their wedlock, the plaintiff and defendant were born.
That's right. You have recorded it yesterday only.
Just to recapitulate.
Manumari had no issue. She adopted Jharkhand.
Sure.
So tell us how the property of Manumari will go to Vishwanath.
The adoption, permitted adoption, it was initially challenged. And there was a decree that the adoption is clear. Thereafter, they preferred a first appeal before the honorable court. And during the pendency of the first appeal, the parties came to compromise. And in the compromise, it was decided that Bhagwat Prasad Bhagat, he was husband of Prashad Bhagat, would get some share out of the property, and then he would recognize the adoption as valid. That the defendant is the adopted son of Manumari.
That was the bargain.
And thereafter, the suit, the appeal was dismissed. The suit, the order passed in the suit remained as it is.
Dismissed means it was disposed of in terms of compromise, no?
The word uses dismissed.
Maybe that we will not pick up one word.
That may be, but I am not on
There
that.
was a compromise.
Because I am not going on the validity or whatever with regard to
Adoption is valid.
Adoption.
Do you want to argue that adoption is invalid?
No, I am on the point that the adoption was not acted upon, as they remained in the joint family property. Dwarka Prasad Bhagat continued to be in the part of the family. The ties were never severed. He performed all the obligations of the elder son, the Muhagni ceremony of his father, the Shradh ceremony of his father. Everything was carried out and exercised by Dwarka Prasad Bhagat, and therefore the property remained intact. And the adoption deed was not acted upon. And that
What is the consequence of adoption deed not acted upon?
Ma'am.
Does it nullify the adoption?
The
Adoption is a past transaction.
the principle of adoption is that the every ties with the natural family, the biological family, get severed.
Suppose there is an adoption, and by a registered document, this adoption was there. So that adoption was also subject matter of challenge, and everything happened in connection with that. You being the plaintiff, the adoption as such, the validity of adoption as such is not under challenge.
No, it is
Not under challenge.
No.
So even if an adopted son performs many activities with respect to his biological father, can he go back to the family?
The ties severs. He cannot perform.
You see, a person can perform last rites even of his neighbor. There is no legal bar,
Correct.
right? There is no legal bar,
Absolutely.
right? Even to third persons, right? A person can perform many rites, many last rites can be performed. There is no doubt. There are so many people who are moving away, they don't come back to attend their parents. Then their near friends, dear friends, they perform the last rites. They do not leave the dead body there itself. Right?
But it is, in my humble submission, it is when there is nobody to perform the last rites.
Need not be. You see, merely because a person is performing the. What is your case? Do you say that the adoption was not acted upon or adoption is invalid?
Yes, ma'am. That is the substantial.
Adoption?
I am confining my argument.
No, we will see your case. No, we will see that. What was your case? You are the plaintiff.
Mine.
You read your case from the plaintiff.
If I may refer to the relevant paragraph 13, ma'am.
You read it from the plaintiff. What was your case?
That for all intent purposes, the plaintiff and the defendant contested the said suit.
No, plaint. Where is your plaint?
I am reading from the plaint.
Plaint?
Paragraph 13.
No. Read it from the plaint. What was your case?
शुरू
The
से-
plaint. आप अपने plaint का copy निकालिए.
हाँ, plaint से देखें।
कौन सा paragraph number?
13 number.
Of the plaint.
Yes. That for all intent purposes, the plaintiff and defendant contested the said suit and the appeal with a clear and mutual understanding that each plaintiff and the defendant shall be entitled equally to the subject matter of the said suit and the appeal. In legal parlance, the suit property was thrown to the said joint family stock. That the said appeal and any compromise according to which the land and the premises schedule B below was given to the defendant who accepted the same for and on behalf of the plaintiff as well as the plaintiff and the defendant always treated the same as their joint property and both the parties are residing there.
You are treating, this is not about adoption. You say the property was thrown in joint family.
But the case is in respect of the property itself. Property is an aspect of the adoption also. This is what they are also trying to make out. And this is what the learned first appellate court has held. Learned first appellate court, while reversing the findings made by the trial court upon evidences, has referred to the law, well settled law, that all the ties are
A
severed.
property which is not a joint family property. This property was originally not a joint family property because it belonged exclusively to this lady. Manumari, it is not a joint family property. Right? How this property gets transferred into a joint family?
Not upon default.
How? How will it get transferred to a joint family? Will devolve upon the legal heirs and successors. But how a property, which is not a joint family property, can form a part of the joint family property?
After the death of the absolute owner, presumably who has acquired the property, that was a self-acquired property.
Yes.
If she dies interstate,
Yes.
the property would be gone.
How?
In view of this succession.
The property will devolve upon the adopted son.
Madam,
The question, when there is a class 1 here, it will not go to the class 2 here.
Madam, that is the point. That is the point. That there was an adoption, but it was never acted upon.
Where have you said that the adoption deed was never acted upon and therefore the adoption stands nullified?
The property was thrown to the family.
Property is another thing. Property is another thing. You see, two brothers in the family, right? There is inter se adoption. One brother gives his child as in adoption to another brother, right? They constitute one family. But when the other brother would die, the property will devolve upon his class 1 here. It will not go to his brother.
When the adoption is acted upon.
Where have you said? Therefore, devolution of property is different from the story of adoption. Where have you stated that the adoption was never acted upon and therefore the adoption has no value?
That is not directly explicitly said.
Even indirectly it is not said.
Not in paragraph 30 it is inherently there, because otherwise if the adoption deed would have been acted upon, it could not be thrown to the joint family of the property. Joint property.
It is not like this. ये आप सेकेंड अपील में बहस कर रहे हैं, इतना आप कहाँ से ये सब बहस कर रहे हैं?
My lord, what will happen when the adoption deed is not acted upon? I want to put a question to myself.
Show me that it is not acted
Because
upon.
I am
No,
saying,
no.
yes, my lord, why I am saying that in the evidences out of the 7 plaintiff witnesses, 4 have categorically stated that all the ceremonies were performed by the elder son, Dwarka Prasad Bhagat, in respect of the death
अरे
of the
भाई,
son.
आप हमको बताइए, वो तो भाई की बात कर रहे हैं. Because they are in the same family. You please appreciate this. 2 brothers, one brother's son is given to the other brother as in adoption. Suppose he performs the last rites of his uncle now, right? You say
He cannot.
who says legally he cannot?
Because all the ties.
Show me. Under which law you say that a person cannot perform a legal rights?
एक बार बस फर्स्ट appellate court का सिर्फ जो relevant portion है बस पढ़ दे रहे हैं.
या सोसाइटल नॉर्म से मत
societal norm से क्या
लीगल नॉर्म से चलिए.
मानो हम बस खाली पढ़ देते हैं. हाँ, उसमें जो settled principle उन्होंने कोट किया है पैरा 24 में, it is a settled principle of Hindu law that by adoption the boy is completely removed from the natural family as regards of civil rights and obligations. He is so completely removed that he has not even to observe pollution. It is in respect of the death, on the birth and death of any member of the family of his birth. The adopted son loses his rights in the co-parental property and his natural family cannot inherit from him, nor is he liable for their deaths. He also ceases to perform funeral ceremonies for those of his family for whom he would otherwise have offered oblations, and he loses all right of inheritance as completely as if he had never been born in his natural family. Now there is a categorical finding by the Royal Trial that he has performed this. Perverse.
That is why there is an appellate court statement.
Well, but appellate court has not considered those evidences.
See, if there is a fight between two people as to who would perform the last rites, there can be an adjudication to that. But merely because he has performed the last rite of his biological father, that will not nullify the adoption. Once the adoption is done, it is done for all times to come. Unless his biological father again undertakes a ceremony of adoption and gets him in his family.
That is what I am also saying, madam.
There is no such ceremony.
Civil rights get severed. He cannot.
He does not have.
It was never acted upon.
He does not have a right to perform. Right? You in the family you are seeing that girls are performing the last rites in spite of the son. In spite of the son. Right?
That happens in this society.
Even the cousins are performing the last rites in spite of biological sons. It is happening. Merely because a person has performed last rite of his biological father, that will not annul the adoption.
That will not annul the adoption when the adoption is acted upon. Here nothing has acted upon. They remain in the same family. The property remained in the same family. He performed discharge all the duties of the
his status as class 1 here has not changed of adopted mother. You show me that his status as class 1 here has changed. Show me some law that his status as class 1 here will cease to exist merely because he has performed the last rite of his biological father.
The law is not direct on that. The law is that all the ties get severed and engrafted into the.
बोल तो रहे पड़ोसी भी कर सकता last rite.
ठीक है ना, तो right से ना accrue कर जाएगा property में, कर सकता है.
Last rites perform करने से inheritance नहीं accrue करता.
हम ये दिखाना चाह रहे हैं कि that
that
remain a family property, but trial court has given a consideration on that.
So you are relying upon para number?
Para number of the trial court?
No, of the claim.
Para number
30.
13, 14.
The learned counsel for the appellant has referred to paragraph 13 and 14 of the plate to submit that the adoption was never acted upon and the suit property was thrown in the joint family property of the parties. Para 13 and 14 of the plaint is quoted as
Para 9 of the trial court judgment starts to deal with the issue of adoption vis-a-vis the rights performed by the defendant. That has been dealt at para 9.
He has referred to paragraph 9 of the trial court judgment.
Trial court judgment. That's it. May I read?
Just a minute. This is a part of your submission.
Well, उसका consideration is.
उसके बाद
page 8 में longish line.
You did para 9.
No,
Of course, pura.
apart from this, apart from this, it has been also argued on behalf of the plaintiff that admittedly the adoption of the defendant has not been accepted by judgment and decree passed in Title Suit number 18 of 1947. In the decree passed in the circumstances, the effect of invalid adoption will be that the defendant neither loses anything nor gains anything, being adopted son of Manumari. In this reference, our attention towards para 220 of the Muhagni's Hindu law and Mullah's Hindu law section 510 511 has been drawn. Thus, according to the plaintiff, on the basis of the above facts, it has been argued that in legal parlance it would be presumed that the property acquired by the defendant Dwarka Prasad has been thrown into the joint Hindu family of the plaintiff and defendant along with their father. In the reply, it has been argued on behalf of defendant that from Exhibit H, that is certified copy of the compromise petition filed in first appeal, 11 of 40A, it will appear that
Just a moment. It will be presumed that the property acquired by Dwarka Prasad. This property was acquired by Dwarka Prasad as adopted son.
other.
Yes, please. Carry on.
It will appear that the compromise contesting party has accepted defendant Dwarka Prasad Bhagat as adopted son of Manumari. On perusal of the compromise petition, I find that the contesting party by para A has accepted the defendant Dwarka Prasad Bhagat as adopted son of Kalicharan Bhagat. And in this circumstance, I am of the opinion that the argument advanced by plaintiff's lawyers in this respect cannot be accepted. So far, other aspect of the argument advanced by both the parties will be considered on the evidence available on the records.
So this plea was rejected
This plea was
by the tribunal.
by the judge. Now,
This argument that
this argument
it
was-
goes back to the family
family,
is rejected.
it starts with that it was an invalid adoption.
No. You see,
Refer me
thus
to
according the
invalid-
property acquired by defendant Dwarka Prasad has been thrown into the joint family, this argument has been rejected.
on the basis
Whatever
that
be the basis, but
No,
this
because-
argument has been rejected by the learned tribunal.
but on, Madam, may I just summarize for a moment? On the basis that the adoption deed is invalid. In evidence, most of
That is not the basis. You are reading into it.
above.
आगे पढ़िए. So far as other aspect,
So far as other aspect argument advanced by both the parties will be considered on the evidence available on the records. In evidence, most of the witnesses of the plaintiff and plaintiff himself has said that it was Dwarka Prasad who has performed last ceremony and Muhagni and Shradh of the natural father Muhagni. This fact has not been denied by the defendant in his evidence. In the circumstances, it will be treated as admission in this aspect. In these circumstances, argument advanced on behalf of the plaintiff that it is a strong circumstance to presume that though the defendant has been adopted by Manumari, he is continued to be the member of joint Hindu family consisting of plaintiff and the defendant as well as their father. So this was accepted on the basis that it was
they themselves constituted a joint family because Manumari was the common ancestor. After all, she was the stepmother. Stepmother. भाई अगर एक वाइफ की डेथ हो जाती है और फैमिली में दूसरी वाइफ आ जाती है, she forms a part of the family. But the point is whether her individual property will become a joint family property.
if he performs the rites.
Even if you forget about it. भाई अगर घर में अगर किसी भी हिंदू में की 2 या 5 शादी हो जाती है one after another, it is not a case that she is an illegitimate or illegal wife, right? That is not the case. Once she enters into the family as a married lady, right, she will have all the rights of a joint family. She will have a right for maintenance. She will have so many rights, right? Under the provisions of Hindu law, whatever is the right of a wife, she will have all those rights. So there is a joint family. There is no doubt on that. There is a joint family.
So after her death, if she dies intestate.
No, she did not die intestate. She died with a son. She died with an adopted son. Need not. Not required. Once she adopts, the property will devolve accordingly, according to succession. He is the class 1 here. It will not go to the class 2 here.
Although this is the finding by the learned trial court, which has been reversed by the learned first appeal.
Let's see.